Dear students, today we are learning probation system in the administration of criminal justice in India. I am Professor Nirmal Kanti Chakraborty, Director, School of Law, KIT University, Bhubaneswar. I did my PhD on probation system in the administration of criminal justice in West Bengal, a critical appraisal of the system. Today, to begin with the module on criminal justice and probation system, I will present to you how probation system is integrated with the criminal justice administration, and in this process we will learn in our criminal justice administration what are the legal provisions which govern our criminal justice system and probation system, and also we will look into how the criminal justice administration probation is interlinked, how far it is being implemented in our criminal justice system. In this module, we will learn admonition in criminal justice system, we will learn probation system in the criminal justice system, we will learn probation in plea bargaining, we will learn also how probation being incorporated and being applied in juvenile justice system under the Juvenile Justice Care and Protection of Children Act 2000. If we look into our criminal justice administration and in the background of probation system, we have to go back to basic concept of correction and punishment, that is whether punishment or sentence should fit the offence or the offender. So, let us look into our criminal justice administration and probation system, how it is working. The first question is, what is probation? To understand probation, let us take two fact situations where courts in India put their mind how to apply their discretion. One fact situation, it happened that a woman having chronic disease husband in the bed, no other alternatives, no way to livelihood, selected a job or a vocation for carrying illegal liquor from a village where illegal liquor being manufactured to a town, and she was apprehended by the police, ultimately before the court. Court is to decide whether to send her to jail or to go for correction through probation system. Court granted probation, and in granting probation, court put into the fact situation and use its discretion. In other situation, a young boy having marriage of her sister 3 days after, having no other alternative to arrange the money for the marriage of her sister, took some money from the cash as he was the cashier, and after the marriage the office handed over him to the police and he admitted the guilty. The court was on dilemma whether to send him to jail or to go for benefit of probation. Court granted probation. So, probation in fact a conditional suspension of sentence, whereby a procedure established that court may release an offender on probation of good conduct for a certain period, maximum 3 years, and on fulfilling that condition without committing further crime, he may be released permanently without going to jail. So, it is a sentencing process. it is a discretion of the court, and conceptually it can be discussed, it is discussed with three different theory. These theoretical explanations are: first one, grace or mercy theory. In grace and mercy theory, the concept of probation described that it is a benefit, it is an advantage, a privilege, a mercy given by the court on certain conditions. On breaking or violating that condition, that mercy would be withdrawn. That means probation order be revoked. The second theory, which is being described by the follower of contract theory, is this: in probation, the probationer has to enter into an agreement that he will observe all the conditions put by the court, and he will obey the orders of the court, and failure of that orders, like breach of contract, he will also have to face the penalty. Like in contract, breach of contract means there would be imposition of penalty. Similarly, in probation, if the probationer fail to observe the contract or the conditions which he agreed to observe, he will also again go to jail and face the penalty. The third concept of probation is custody theory. In this theory, it is believed that any probationer, when released under benefit of probation of good conduct, he is under the legal custody of the court. So he has to obey the court orders and conditions. On breaking of any condition, court will revoke that probation or benefit, and he will also be sent to the prison for violation, and he will not be given the freedom, conditional freedom, which was extended. So which was extended to a probationer, that probation system, when came to our legal system of the world. If we go back to the history of probation, it is also a voluntary zeal of one Boston cobbler, namely John Augustus. In 1841, in USA, in Boston town, John Augustus one morning saw that a person in the court was crying and asking him to take on bail and promising that he will not take again drinks or alcohol if he is being freed from the correctional home. Augustus took him on bail, and thereby he started to take the offenders who committed very minor offences and put under his supervision. When he died in 1958, there are more than 2,000 such probationers were under his supervision. Thus began the probation system, and John Augustus being treated as father of probation system. But during the same period, 1841, another magistrate, Matthew Davenport Hill, Warwickshire Quarter Sessions in UK, claimed that probation was his concept or brainchild. He discontinued even one-day jail within the court, and even pardon in the court itself at the time of sentencing. But probation in its true sense, in the sense where the offender is to undergo a supervision, that really came through the voluntary works of John Augustus. If we look into the legal aspect legal origin, statutory probation, that starts in 1878 in Massachusetts, USA, where a probation officer was appointed from the police, and he was under the supervision of the court to look after the person released on probation of good conduct. In UK also, first statute on probation came in 1879. But if we look into our Indian legal system, we can say that first seeds of probation started in our Criminal Procedure Code 1898 in section 562, which now in our Criminal Procedure Code 1973 under section 360 of 1973, the same provisions being followed by Indian courts. But the statute on probation, the law which governs probation system in the country mainly, is the Probation of Offenders Act 1958.